This week, the National Constitution Center and Texas A&M University School of Law convened a Supreme Court Review Symposium with leading constitutional scholars and commentators. Hello, friends. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. In this episode, I'm joined by three of America's leading Supreme Court commentators, Jess Bravin of the Wall Street Journal, Jan Crawford of CBS News, and Fred Smith Jr. of Stanford Law School. Together, we explore polarization on the court and the role of the media and the president in shaping public perceptions. Enjoy the show. Friends, our last panel ended with a vigorous discussion of whether the current court represents the triumph of John Marshall or Neville Chamberlain, and also the competing visions of Justice Jackson and Justice Barrett. And I want to start with that remarkable debate now. In the Trump and Kasich case, Justice Jackson, in her separate dissent, accused the conservative majority of creating a zone of lawlessness that represented an existential threat to the rule of law. And Justice Barrett responded for 6 justices in the majority that Justice Barrett's dissent has no basis in 2 centuries of precedent, not to mention the Constitution. Jess, you're so thoughtful in your reporting. Who's right? And is this historically unusual?
Well, it's emphatically the province and duty of the news department not to say who's right,
Excellent.
but simply to say what they have to say and leave and take readers up to the step of drawing their own conclusions. And I think that it really starts with the presumptions that readers and audiences have about whether this is a moment of tremendous tension and crisis for the country, as Justice Jackson suggested, or whether that's an exaggeration and things are not so different than they are as they normally are. And that's really the majority's take of what's going on. There's nothing, this is not some kind of crazy emergency, says the majority, and yes it is, says Justice Jackson, and some of the other opinions we've seen, also other liberals in dissent saying the same thing. So what they are doing is, they are reflecting the tensions in the country as a whole, and those are not so much legal arguments as they are senses of what the national mood is, what the zeitgeist is in the United States, and whether the Trump administration is something anomalous and horrific, or something that is just another evolution of the line of democratic succession.
Thanks so much for that. Jan, a version of the same question, but could they both be right? And is this unusual?
Wait, what was the last part?
Is this unusual historically? Have we seen before justices accusing each other of either existentially threatening the rule of law or crying wolf?
I think the language may be a little more pronounced than some of the things, but it's not unusual for justices to have pretty strong views in their dissents. And what I've been most struck by seeing kind of this clash between Justice Barrett and Justice Jackson is when I think back to the 1991-1992 term, when Justice Clarence Thomas joined the court. And unlike some of the other justices, Justice Alito told me once when he came on the court, he felt like he had made a mistake when he was on the Third Circuit. He immediately started arguing to, re-argue cases and rethink different issues. And so he decided that he was going to spend a year, just that first year, just kind of getting a lay of the land, a feel for the court. When you move into a new neighborhood, the first thing you do is, you don't go and tell all your neighbors they need to repaint their houses and the color of your choice. So that was mainly how most justices do it, not Justice Jackson. She's going to tell you, yeah, you need to repaint your house, and in fact, you need to tear that whole thing down. And so that has been very unusual to see her being so assertive, not only in the dissents this year, but certainly in her questions from the bench, where she is literally talking the most from the bench of any of the justices. That's highly unusual. Why I say it reminds me of Justice Thomas is when we think back to, and it's really nice to be here, and I hope you don't take offense at this, but when I go speak at law schools, I'll say, like, when we think back to 1991, or when we think back to the year 2000 and Bush versus Gore, and, they're like, they're not even born yet. So it makes you realize these years go fast. But when we think back to 1991, when Justice Thomas joined the court, after that brutal confirmation hearing, a narrative very quickly developed that he didn't belong on the court, that he was really Scalia's intellectual understudy, his puppet. And that narrative, which I think persists to some extent today, is patently and demonstrably false. You can go to the papers of Justice Harry Blackmun. On that first year on the bench, if any justice changed their vote that year to join the other, it was Scalia changing his vote to join Justice Thomas. Justice Thomas joined the court and immediately began articulating very bold perspectives on the law. And arguing the court should be rethinking vast areas of their jurisprudence, particularly in the issue of habeas corpus and criminal law. And in the back half of the term, he circulated an opinion in a habeas case, that so offended Justice O'Connor that in her dissent, she used his name 18 times. Justice Thomas does not understand. Justice Thomas misstates the law. Justice Thomas mischaracterizes a previous opinion over and over. That is very unusual. Typically, the dissenting justice will say the majority, or my colleague, or it was extremely unusual, and it reflected her response to Justice Thomas's bold views when he first got on the court. And what we see that term is, and why this term is so pivotal, and why I would caution liberals who are cheering on Justice Jackson now, is that term is when you saw Justice O'Connor begin to move to the left. She reacted so strongly at some of the positions that Justice Thomas was taking. She would dissent in cases, but she did not join a single one of his dissents. She would always write separately. Because when a new justice joins the court, it's like the chess pieces get rearranged, right? And so sometimes it can cause people to rethink their alliances, re-examine different rulings. That term, when Justice Thomas joined, didn't really just rearrange the chess pieces, it just turned the whole chessboard upside down. So you saw Justice O'Connor move more to the left. You saw Justice Souter, I think Scalia helped a little bit here, pushed more to the left, Justice Kennedy. And that was the term when the court refused to overturn Roe versus Wade, refused to allow school prayer at graduations, over and over. A court of 7 justices nominated by Republican presidents in case after case was a huge disappointment to conservatives. So when we see this kind of back and forth now in the writings and on the bench between the justices, it does give some concern that perhaps Justice Barrett has been disappointing sometimes to conservatives. I'm not on the big cases, and I'm sorry, Sarah, I apologize I know the first panel, Sarah gets frustrated with some of the big cases, but some of the big cases like overturning Roe versus Wade, I mean, she was the vote with conservatives. But Justice Kagan is very strategic, and in some ways like the Chief Justice, and I think had really thought, that Justice Barrett and perhaps Justice Kavanaugh, maybe the Chief, those in the middle, you can have a conversation with them, what does that do? Open things up for compromise potentially, or at least to consider compromise, so that there is possibility of finding perhaps some common ground. And now when we see that kind of language in that kind of case, the concern would be that you're really doing yourself no favors if you're hoping to find some kind of compromise or consensus or common ground on anything. Because remember, there are only 3 liberals on the Supreme Court. You've got to be able to try to get 2 of those conservatives if you want to have a majority opinion. So that was kind of what I took away. I think some of the language we've seen this term, and we can talk about this later, does a disservice. But it's not unprecedented. And Scalia sure had some doozies too in his day.
Such an important point about how the polarizing rhetoric of justices can drive each other apart. Justice O'Connor's response to Justice Scalia was, "Sticks and stones can break my bones." And then she said that probably isn't true. And she did indeed move to the center, as you said. And Justice Kagan is having a different strategy than Justice Jackson. Fred Smith, same question, a version of who's right, not in the sense of who you think is correct, but these are completely different views of what the court is doing. Can they both be right? And then history. I'm thinking about the great moments of court polarization. After the court overturned the Gold cases after the Civil War, within the space of only a year, the dissenters accused the majority of acting pure politics. Justice Jackson sniped at Justice Black during the Nuremberg trials and accused him of being a politician. Have we ever seen anything like this in history before?
I'll start with the substantive question, right? Who's right? And specifically the charge from the dissent that the nationwide injunction opinion has created a zone of lawlessness for the president. I think it's too early to entirely say who is right, in part because there are still three potential possibilities to hold the executive accountable. One is the class action, right? So we don't know just how strictly the Supreme Court is going to kind of rein in that category, but it could be that we're in a situation where what used to be nationwide injunctions, that a lot of them just get funneled into a different mechanism, in which case we're not in a setting in which there's a zone of lawlessness for the president. The second category is situations in which a state is a litigant, and because of the importance of uniformity, they can make the case that only a nationwide injunction will solve their specific injury, which the court also left open in CASA. And then the third possibility is that they did seem to reserve for themselves the ability to say what the law is in a way that would bind the president. Now, that third one is the trickiest, right? Because it depends on a lot, right? So the example I give is a president issues an executive order that says, no one can speak ill of me. And
don't give him any ideas.
This is just a complete hypothetical. I have no president in mind.
We're going to get a new executive order.
I actually picked this example in part because it's not necessarily like left or right. It's a First Amendment issue. Johnny goes to court and says, I want to be able to say the following thing against the president. A federal district court can issue an injunction for Johnny, but not for anybody else, right? And what matters at that moment is, does the executive appeal? Because if the executive doesn't appeal, it never gets to the Supreme Court. And that third mechanism, the Supreme Court speaking, doesn't really exist, right? It would require me to sue, and you to sue, and you to sue, and anyone in this room who wants to ever say anything bad about a president, it would require them to sue in order to get relief. It also depends on the possibility of whether or not, if a lot of district courts are saying something is unconstitutional, will the executive just press the pause button or not, right? And at oral argument, at least, the Solicitor General strongly suggested that it's not a policy, it's not a uniform policy of the executive to follow even what a circuit court says within a circuit, right? And so are we in a zone of lawlessness? A lot depends on those three mechanisms of accountability and how they wind up. On the question of, is this rhetoric historically unprecedented, I would say no. And I would say that even in this century, it, in my mind, isn't at all unprecedented. I think about the Obergefell dissent by Justice Scalia, where he said that he would rather hide his head in a bag than join an opinion that the majority said. He said that the majority opinion was like aphorisms from a fortune cookie. He said that that everyone on the court was essentially from the Northeast, that none of the people in the majority were from the West. And then he said, because Justice Kennedy was from California, California doesn't count. In my mind, just in terms of, at least from a collegiality perspective, and debates between the justices, at least, to me, this doesn't really register.
Neville Chamberlain or John Marshall, and let's talk about the question of presidential defiance of the Supreme Court. Our previous panelists suggested that if the president disobeyed an unambiguous order of the U.S. Supreme Court, that would be a constitutional crisis. We've never seen it before in American history. Andrew Jackson is supposed to have said, John Marshall's made his decision, now let him enforce it. But even if he didn't utter the words, the court never ordered him to do anything, and he never had to defy Marshall. Lincoln briefly defined Chief Justice Taney on suspending the writ of habeas corpus during the Civil War, but Taney was sitting as a district judge and it wasn't an order of the full court. So we haven't seen it before. And the big question, Jess, is the court afraid that President Trump will defy it? Is Chief Justice Roberts trying to avoid a direct confrontation? Steve Vladeck, quoted Marshall, who said, "I'm not fond of butting my head against a wall in sport." So he tried to avoid those direct conflicts with President Jefferson. And are we going to see the president defying the court or not?
Well, Nazi analogies are always tough, but there's another.
No reason to resist them.
There's also Marshall Patent. The question is, a question like that assumes that the court knows that Trump is wrong and disagrees with him and is, for strategic reasons, choosing not to say so. And I think there is another possibility, which some people perhaps overlook, which is that they think Trump is right, and they don't believe that like all right-thinking people, they have to stop him, and they're just waiting until he's looking the other way to do it. I think that you have to look at this court. The majority of the court, the members, their legal careers were built viewing much of the jurisprudence that they had inherited as mistaken and misguided, thinking their job was to correct that, believing strongly in executive power, and not looking at Trump as this malignant force that they have to find some way to resist. I don't know that they are the resistance. I think that we should take much of what the court does as reflecting what they think. And when they say, as they did today in the emergency order on the reduction in force memorandum, that the government is likely to prevail, is because they get to decide who prevails, and they think that he is going to prevail. So we know, yes, there have been a couple of orders involving habeas corpus and deportations where the court did stop the president from moving forward. There was the comment from the Chief Justice earlier in the year about impeachment maybe being a little bit out of bounds when you disagree with a court decision. But I think that we shouldn't assume that they know better than the actual orders that they are issuing.
Jan just suggests that the court is unlikely to issue orders the president defies because it may not check him on the big questions. What about the lower courts? Is the administration complying in good faith with the orders of lower courts, including Judge Boasberg? And how is the U.S. Supreme Court responding?
I think that I actually have been quite impressed with some of the briefing in these cases, the filings that the government has made. It's actually been pretty good, considering that it's just a deluge. And I'm not really sure how some of these district court and appeals court judges are even keeping up with some of this. And that is obviously part of the strategy. I think the concern is that they are going to defy the lower courts and certainly the Supreme Court, but they haven't yet. I mean, they've come close. And I know our previous panel would disagree with this, but I do think the court is worried about that, which explains some of one of the rulings that you mentioned and how they handled that and said that had to be sent back to Texas, where the habeas matter. But they haven't yet. I think one of the things that's notable is that in the case involving the third-party removals, you could argue that it was the federal district court judge that was defying the Supreme Court when the court said that they were lifting this injunction, and the judge said, well, only part of it, the other part's still going to be in place, which prompted a pretty extraordinary clarifying order from the Supreme Court that they really meant what they said. I think my biggest frustration with some of these emergency orders is that they're coming to the court in a preliminary posture. For example, the case today, the reduction of force case. Obviously, we all know, or I'm sure most of you, you obviously are very engaged and follow the news closely. And Jeff, you do such a terrific job here. We are so lucky to have Jeff helming the Constitution Center. And y'all are so lucky to be in Philadelphia to get to come to these things.
Very much.
But the order today and the reduction in force, obviously President Trump issued an executive order and a memo directing the agencies to, just basically develop plans for cutting massive numbers of federal employees in their workforces consistent with the law. The federal judge said that order and memorandum was unlawful. The Supreme Court today in an 8-1 order, which means that Justice Kagan and Justice Sotomayor agree with it, said, well, no, the executive order and the memo are not lawful. And the government was likely to prevail on that in the unsigned order, the court said. So the agencies can go about formulating these plans, but when you get those plans, those could all be challenged. So the order today was extremely preliminary, really didn't decide anything other than, okay, the lower federal court went way too far in blocking the order as unlawful. And so sure, the agencies can go about developing restructuring plans under the terms of this executive order, but all of those plans can be challenged in court. So bring them back when you want to challenge them, and that's what's going to happen. So this was really, kind of the initial volley in any of these cases. They're very premature. So I agree that it's very difficult to draw any conclusions on what the court's going to do when they actually get to the merits of some of these cases, especially the case that everyone calls birthright citizenship, which was never about birthright citizenship. That case was about whether or not federal district court judges could issue these sweeping nationwide injunctions that would bind every person across the country in any issue, even if they weren't parties before the court. And as we heard, the presidents in both parties have long opposed these. President Biden, Solicitor General, urged the Supreme Court to please rein in some of these nationwide injunctions. And that's all the court did in that case. The court said that, limited, and I agree with you, Fred, that it's probably not going to have that much of an impact at all. Limited the kind of circumstances when judges could enter these nationwide injunctions, but that doesn't mean that birthright citizenship will ever see the light of day. They're just going to have to challenge it in the proper way. So one way of looking at this court is not they're rubber stamping things Trump's doing, but they're actually demanding that process and procedures be followed.
Fred Smith, you've written a lot about judicial legitimacy. The moments when the court's been most concerned about its legitimacy include Little Rock, where all 9 justices signed Cooper v. Aaron in hand because they're so afraid of being defied. Is this court afraid of being defied? We've seen it act together in saying that President Trump had to facilitate the return of Mr. Garcia, and will its concern about legitimacy affect its confrontations with the president moving forward?
Yeah. So, first I want to just clarify. I didn't say that the opinion isn't going to have a big effect.
I'm sorry.
No, it's okay. Yeah. I said was that we don't.
APA cases too.
We don't know how far. We don't yet know just how what the effect will be. You mentioned the APA cases, so since you did, I do want to point this out, because I think this is something that I am concerned about. I am concerned that the Supreme Court's nationwide injunction opinion may have made one of the biggest problems with nationwide injunctions worse. So one of the biggest problems with nationwide injunctions is that people go to courts in a place where they're quite certain, or they feel quite certain that they're going to win. And then you have these situations where a judge of one party is issuing a ruling against the president of the other party, and then you just see that over and over again, and it affects the perception of the Supreme Court in ways that are troubling. It's not clear to me that this opinion is going to solve that problem, and I think it might make it worse because of the APA. So this is something that we're not going to necessarily immediately see, but I'll give the example of the mifepristone case, where a judge issued what it looks like, there were a lot of critiques and people referenced it as a nationwide injunction because it was a nationwide order vacating a regulation by the FDA. Justice Kavanaugh's concurrence makes clear that setting aside regulations does not fall within the sweep of CASA, right? So when it comes to environmental regulations, et cetera, and when in a future administration, when there are lower court judges who are doing that, and the American public was told lower court judges can't do that anymore, I think that the problem will even be worse. And only Congress is institutionally situated to solve the national injunction problem by mechanisms like three-judge panels or specialized courts, things that the Supreme Court just isn't institutionally capable of doing. So that's my fuller, I wasn't on the nationwide injunction panel, that's my fuller perspective on that. In terms of, is the Supreme Court concerned about about future confrontations with the presidency? It's really kind of hard to say, but historically that is something that that the court has been concerned about. The Marbury versus Madison example is, of course, the clearest. And even in Federalist 78, right, Alexander Hamilton reminds that the courts, they don't have the power of the purse, they don't have the power of the sword, right? And so they really have always understood that a reservoir of some degree of acceptance from the American public, at least enough that the American public believes that it's important to follow their orders, that has always been an important part of the court's institutional capital. And what's hard in these moments is that there's kind of these short-term ways of thinking about this and longer-term ways of thinking about this, and it's impossible sometimes to predict how things will be viewed in the longer term, right? So sometimes the way we think about this is, well, if the court just kind of steps back and they don't have the confrontation and they save their capital, then they're kind of protecting themselves, right? But historically, there's moments in which the court looks worse because it didn't act, right? And there's instances in which the court acting ended up giving it more capital. No opinion gave the Supreme Court more capital than Brown, right? And that was not a moment of the Supreme Court stepping back. But in terms of kind of the longer term perception, in terms of where the American public ultimately went on those issues, it ended up benefiting them, right? And so it's a difficult kind of prediction to sort of make in terms of whether or not standing back versus acting is the move that's going to best preserve the court's capital. But I would say that in the close cases, it's better to act. And I'm gonna say my kind of bomb-throwing sort of statement. I think that if a court has jurisdiction and has the ability to stop an ongoing constitutional violation and refuses to do so, it is ethically the equivalent of when a police officer is watching a fellow officer commit a violation and doesn't intervene to stop it. They become complicit in the violation. And so to the extent, if a court really believes that it has the jurisdiction, it has the ability to stop an ongoing constitutional violation, and it does not do so, I find that concerning.
A powerful point that the court sometimes establishes its legitimacy by acting, and also that it's hard to tell, and that the court thought it was being heroic in Dred Scott, but proved to be wrong. But in Brown, it was the source of its capital. When you think of the areas where the court is most likely to confront the president, Jess, what will it be? After all, in the first Trump administration, President Trump lost a fair amount before the court, so surely he's going to suffer some important defeats. What are the big areas where the court is likely to check him?
Well, one thing, the question of whether President Trump would defy the Supreme Court was a question that also occurred in his first term, and he came close in at least one case, and that was the citizenship question on the census form. And after the Supreme Court was quite clear, the Chief Justice writing that opinion, saying that the disingenuous reasons given for placing that question on the form invalidated the process under the Administrative Procedure Act. The president, through his preferred medium, then known as Twitter, gave various contradictory instructions to DOJ attorneys who were often left sort of unsure what to say when they were in courts in follow-up hearings after that decision. And I certainly know from our reporting at the time, and you probably too, that there was discussion at the Department of Justice and the White House about whether there was some way to decide that they didn't have to comply with what that opinion seemed to say. So it's been, in the background throughout the Trump approach to Article 2. In terms of what cases are going to really raise, give the court less breathing room than something about, whether agencies can prepare layoff plans. One thing I would say maybe is the punitive orders against law firms.
Oh, yeah. But that hasn't even got to the court, right? I mean,
No, it's not there yet. It's not. Well, the government is lost,
Yeah,
and
they
everything.
haven't even
They've not filed any emergency applications on that yet. But they just did appeal one of them to the D.C. Circuit. I mean, we thought, it's possible they'll just kind of drop it, and they'll just, until they run out of law firms to issue executive orders against, but no, they are appealing one, and they may appeal the others. And if they take that one to the Supreme Court, I think it will be a very interesting test for them, because it's a novel use of an executive order, and there are, we haven't had a lot of bill of attainder type questions, come before the Supreme Court recently. I think that one is one where they may push back. And similarly, when there seem to be viewpoint discrimination cases, targeting of universities because of their, internal organization or their curricular choices. I think that when the court's sort of very aggressive free speech jurisprudence runs into executive orders, unilateral actions by the president intended to punish speech he doesn't like or to repress political opposition, I think those are the ones will be the most interesting. Ones involving the organization of the executive branch, I think the court is more likely to give the president much more leeway.
Well, they've signaled that in, recent cases, including one when Biden was in the White House, that they're going to give him, a president should have more leeway in replacing some of those, like NLRB and some of those boards.
I wanted, though, just to add a little gloss on what Fred said about Brown. While Brown had been argued once under Chief Justice Vinson. They couldn't reach a decision. Chief Justice Warren comes in and says, we're going to do this. And that was true. But then a few years later, when they had the interracial marriage cases, we know from looking at the justices' papers that they chose not to go forward in striking down those miscegenation laws because they were afraid it was too much to add that on top of school desegregation. I mean, they eventually did. They got around to it in Loving versus Virginia, but that question arose years before, and they already knew that was unconstitutional, and they decided to wait because of this very issue, I think, if I'm not mistaken, Jeff.
A crucial observation, absolutely. Justice Frankfurter thought it would be bad for the country, and the South wasn't ready for it, and as a result, he delayed for more than a decade after Brown until the court finally struck down anti-miscegenation laws. Fred Smith, what is the role of pragmatism on this court? In Trump v. U.S., Chief Justice Roberts' majority opinion seemed to be based not in text or original understanding, but on a pragmatic concern that future presidents not prosecute their predecessors. And we've seen the liberals accusing the conservatives of being guided by pragmatism. Also in the Section 3 14th Amendment cases, are these conservatives in fact pragmatists?
I think in the two cases that you just mentioned, it's hard to fully understand them on any other basis. And attempting to sort of describe them in any other basis, actually, I found distorts the Constitution. It's less clarifying in terms of what the Constitution means than not, that it's actually better just to acknowledge that in the Section 3 case, that a big part of what was going on was the practical concern that if states were in a position of disqualifying presidents, that it could lead to untold potential problems for the democracy. And they reached the conclusion that as a result, they needed to intervene. And then they found enough things that looked enough like law to get there. And if you try to, because if you try to actually parse it out and describe it as, well, this is what Section 5 of the 14th Amendment means in terms of congressional power, et cetera, it actually makes it harder to really understand what Section 5 of the 14th Amendment is all about than to kind of understand the practical reality. Now, in the criminal prosecution case, that one is in some ways trickier because it's not altogether out of bounds compared to where the court reached with respect to civil suits against the president in Nixon versus Fitzgerald, right? So it can be explained actually on the legal basis of precedent. I think what gives people pause about that one is that there was no originalism. And so people have kind of come to accept that when it comes to novel constitutional questions, that's where this court is going to look. And instead, it looked to a precedent from 40 years ago and extended it. And so, in terms of the question of why did they look to precedent versus why did they look to originalism, that might be able to be explained on practical grounds. But I think the opinion itself can be explained by virtue of kind of extending some principles that were already present in Nixon versus Fitzgerald. But on Section 3 specifically, I think that one's hard to understand on any other basis than they thought that this was the best way to protect the Republic.
Jess, Jan, and you and I have been covering the court for a very long time, and things sure look different today than they did when I started at the beginning of the 90s and when both of you started in journalism. How has the coverage of the court affected the court itself, if it has? And are the justices responsive to the explosion of new media outlets, from blogs to social media, partisan and nonpartisan alike? How are they responding? Jess?
Well, actually, when we heard the other panel, and there was when Jan was talking about Sandra Day O'Connor, I thought of your famous cover story about it's just Justice O'Connor's world, and we're just living in it. And I was thinking, boy, it's a really different world now. I don't think we're living in her world anymore. Yeah. We're living in a different one today. Well, I think the Supreme Court members have a bifurcated view of these things. I think they simultaneously don't care at all about the coverage of the court, and they also care intensely about it at the same time. They don't believe they're influenced by it, but from offhand comments, I'd say they read a lot. They're very familiar with podcasts and blogs, and they're interested in what people are saying about them. Whether that affects what they do, we don't know, but there was a lot of criticism from the right wing of Justice Barrett earlier in this term when she cast a number of votes that went against the Trump administration's interest. And I know that, we've seen some of the people in the exosphere, or whatever it's called, claiming some responsibility for helping her get back on the right path in more recent decisions. Now, I doubt that she believes that that's what's going on, but there is this question of how much does the reflected view of themselves affect what the justices do? The court in some ways has made itself more transparent in that they have now live transmission of arguments, and the briefs and opinions are posted immediately, and there is more opportunity for people to see the product of the court. But there is certainly no more insight into how the court is producing that material, especially on the emergency docket, except for the occasional, too occasional in my view, leak of drafts or internal discussions of what's going on. I wish we could say more clearly whether, the court keeps its distance from most journalists, as you know, more than some former members did, I think. And that is because they are more distrustful of the media. I think that the leak of the Dobbs opinion caused things to get tighter around the Supreme Court in a number of ways. It also caused a lot of news organizations to treat the court more like a political institution and cover it more like a political institution and look at the personal relationships of the justices, look at potential conflicts of interest, look at who they're talking to, being influenced by, more like they cover political officials. And I don't think the court likes that, and that increases their own cynicism about the way they're being covered. But, ultimately, though, all of them pretty much live in a bubble where they're surrounded by people who tell them how brilliant they are and how correct their views are and seek to help them, attain the results they are after. They don't, I think, apart from their colleagues who certainly do criticize them, they do have different opinions, but the world that they inhabit in the Supreme Court building and the places they choose to go generally is very favorable to each of the justices. I mean, they select where they go, and that tends to be where they go. If you ever look at an interview when a justice gives, whether it's about a book that has come out or they're visiting a judicial conference or law school, usually the interviewer is someone who is very sympathetic and doesn't ask the kinds of questions that Jan would ask if she had the opportunity to do it. And therefore, I don't know that the justices take very, very seriously a lot of the criticism that appears in the press.
Thanks for that. Final thoughts from Jan and Fred. Jan, how has the court responded to the transformation of coverage so that the court is now covered as if it's a political institution? And has that coverage of the court as a political institution increased understanding of the court or not?
No. I think, obviously, there's been tremendous change. I started covering the court in 1994. And like Jess said, we wouldn't get argument transcripts for 10 to 15 days. Now you get them within the hour. And so when we would go in the press room after an argument, because we all had to attend because there were no live audio, you had to be there to know what was happening. We would literally, and we were competitors, but we wanted to get it right. So we would compare notes, like, wait, did the Chief Justice say that, or who said that, so that we could really have this understanding of what the court was doing so we could better explain it to people. I was with the Chicago Tribune then, but who people were reading back home who couldn't be in the court listening to those arguments. Obviously now that's all changed. We have live audio. That only started in 2000 with Bush versus Gore, and only for very few cases. And I will tell you, this Bush versus Gore, that was recorded on cassette tapes. And so they ran that out to the satellite truck that was doing the feed after the argument concluded, and they started the playback. So now we have live, instantaneous audio transmission. So it's been, and filings, those are all online, like Jess said. You used to have to go into the press room and request the briefs. They were all in paper. I know I sound like some old, we didn't go to horse and buggy then, but whatever. It was pretty close. I don't think we had cell phones then either. But at any rate, so all this technology has meant, it's tremendous. It's opened the court up in ways that people can now listen to the court. They can have a greater understanding of the court. They can get more engaged in what the court is doing. It's also led to new mediums, different people who cover the court. And I don't think, and that's where I think we've seen the biggest change, setting aside the composition of the court, the tools and how people do it and technology. The biggest change is how the court's covered, and I do not believe that it is necessarily for the better. It is covered as a political institution because most of the people disagree with the outcome. They decided, it started when, I guess, when Senator McConnell refused to fill Scalia's seat and kept that open, there was tremendous rage there. But we really saw the turning point after the leak of the Dobbs decision, which overturned Roe versus Wade. And, we really started seeing this drumbeat of that the court's a political institution, that it's corrupt. I mean, if you believe everything you read, you're going to think the court is corrupt, lawless, beholden to Trump, driven by politics. All of that is patently false. It's not true. These are justices who have very different views on the law. They're engaged in this titanic struggle over their ideologies. They're not corrupt. They're not in the tank for Trump. I mean, I'll leave it at that. But they're up there. They're 9 really engaged, smart people trying to figure out what the right answers are. These are hard cases. They typically take cases that have divided the really smart people on the lower courts. And so they have to figure out what's the answer. And that's always what I look at when the decision comes down. Not like, well, they better do this. Like, how are they going to figure this one out? What are they going to do? And that's our job as journalists. That is what our mission should be, is to explain to people who are standing in their shoes that can't be there, can't listen, what is the court doing and how it affects your life. And a lot of the stuff that we've seen recently from the court, some of this breathless tone about scandals, which aren't even scandals, people Venmoing money so they can go buy hot dogs for law clerk parties. So, Justice Thomas's role in the Horatio Alger Society. The New York Times literally sent a reporter and a photographer to Germany to interview a princess who had hosted Justice Alito for a concert, which he reported, by the way, on his financial disclosures. But there's fed this narrative that this court is corrupt. And, my point is, where's the other side? Why are we just focusing on one side? Because, we've had Justice Ginsburg and Breyer. I mean, they've flown all over the world courtesy of billionaires. So, let's be fair. But when you put this narrative out there that you've got your thumb on the scale, that doesn't serve anyone. That, in fact, hurts the court and its view and how people view it as an institution. It undermines the credibility of the court, and that is dangerous, I think, for democracy. I mean, we have a responsibility to cover the court fairly and objectively. I think we try to do that, but not everybody does. And so I guess I would just say, be skeptical of some of the things you're seeing and some of the particularly things on social media, edgy law professors who are trying to build their brand, not the one here tonight. But I would be very careful of some of the narratives out there because some of it is just not true.
Thank you so much for that. Fred Smith, last word in this great discussion is to you. As Jan mentions, on the one hand, we live in a highly polarized media and political environment. On the other, it's the most marvelous time in history to study the law because all of the primary sources are online. And how lucky we are to live in a world where we can hear the oral arguments and read the briefs and read the majority opinions and the dissents and hear thoughtful discussions like this one and make up our own minds. That's, of course, the mission of the National Constitution Center and our new annual Supreme Court review with the Texas A&M Structural Center on the Constitution. Fred Smith, when you teach your students about the court, how do you encourage them to learn about it, and what should our audience here do to educate themselves about the Constitution and the Supreme Court?
Oh, wow. Okay. I thought I was going to answer that question.
By the way, we did not get any questions tonight in advance. I hope y'all appreciate. We're like, whoa, where's that coming from? I feel like some of the panels before, they had a sense of what was going to be asked. We didn't.
That's why ours was better.
Well, in terms of how I teach my students, my view is that my job is just to teach the law and to help them understand it the best that I can. And I find that, I've taught for 15 years, and I found that students' relationship to the court isn't really linear. Like, it doesn't just go like this and it doesn't just go like that. It actually, at different moments, students have different kind of reactions. And I think I do have a job of making sure that cynicism doesn't cloud their ability to understand the law. And what that looks like in different moments kind of shifts, because the importance is understanding. That's what I see my job as. I do want to answer the question of just kind of what the press coverage has meant for the court's own actions. And then I promise I'll end with something optimistic in saying so. I think it has affected some of their institutional practices, right? And we've heard about some of them. I think the relationship to the emergency docket, yes, we don't have nearly enough opinions, but we have more than we used to. We don't have enough oral argument, but we have more than we used to. There used to be none. And I think it's hard to understand that institutional change without appreciating the critiques that the court was facing, and it listened. Some of the critiques around disclosures resulted in the Supreme Court adopting. It's an ethics policy. Again, many people think it doesn't go far enough, but it's more than they had before, right? And so that's an example, too, of there being dialogue between the Fourth Estate and the Supreme Court. So that's the most optimistic statement that I can end on.
Beautifully done for ending us on a note of optimism, and to all three of our panelists for increasing awareness and understanding of the Constitution. Please join me in thanking them. This conversation is presented in partnership with the NCC and the Center on the Structural Constitution at Texas A&M University School of Law. For more from the 2025 Supreme Court Review Symposium, visit constitutioncenter.org/media library. This episode was produced by Bill Pollack and Griffin Ritchie. It was engineered by Dave Stotts, Greg Scheckler, and Bill Pollack. Research was provided by Gyuha Lee, Griffin Ritchie, Cooper Smith, Trey Sullivan, and Tristan Worsham. Friends, I'm so excited that in September, Ken Burns and I are launching a special podcast, Pursuit, the Founder's Guide to Happiness. We have interviews with Ken and leading historians, and I can't wait to share it with you in September. Please recommend the show to friends, colleagues, or anyone anywhere who's eager for a weekly dose of constitutional debate. Sign up for the newsletter at constitutioncenter.org/connect. And always remember, when you wake and sleep, that the National Constitution Center is a private nonprofit. This podcast and all our work is made possible thanks to the generosity, passion, and engagement of people from across the country who are inspired by our nonpartisan mission of lifelong learning. Please consider supporting our efforts by donating today at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Jeffrey Rosen.